usually invite citizens to share their opinions, concerns, and recommendations. So there you have it, 4 accountability tools of Parliament that are used to make sure government run right. Visit jampja.org to find contact information for your MP. Invite them to meet with the community so they can better represent your issues and concerns in Parliament and keep government accountable. Get involved and let's make Jamaica land we love, Jamaica land we own, and Jamaica land we run well. A message from the Jamaica Accountability Meter Portal, funded by the European Union and the Inter-American Development Bank in partnership with the Private Sector Organization of Jamaica.
MSMEs around the country and give out prizes. The IDB supported us with $250,000 US last year, and we're going to have others this year to help us as well. So happy MSME Day to so many of the 400,000 or so MSME businesses that are in Jamaica. And here we start with our Joint Select Committee meeting, looking at the matrices that have been set out by the Companies Office and the Ministry as we look at the Act of Security, Interest in Personal Property 2013 to make those amendments. Welcome. I see Ms. Leon. You're going to lead this morning, Shelley. Thank you very much. But she has team members, and from the Ministry, of course, we have our senior legal officer and an assistant. I see we have Mr. Allen from the Legal Reform Department and his colleague. Welcome all. I'm going to ask for apologies, which I've seen, one here from Senator Dana Morris-Dixon. That's the only formal apology we've had. And we're going to take the confirmation of the minutes which have been circulated, so we're taking them as read. And if there are any comments or amendments from members online, please say so, and if not, then I'm going to ask Member Julian Robinson to move, and the seconder from Senator Sherry. And Senator Golden Campbell, you second? Hello, Senator Golden Campbell, are you hearing us?
Second.
All right, Member Hilton does, but I want you to confirm that we have Senator Golden Campbell on time. She is on time, so that we have and keep quorum. Ms. Leon, you're on.
Good morning, everyone. So last time we had reviewed up to Section 46, the recommendation made by the Jamaica's Bankers Association, but there was one matter that we had indicated that we would provide a response to, and this is in regard to the recommendation that
You need to identify the page and the document from which you speak so that we can follow you. I called, are you dealing with the mothership document or the matrix from the ministry?
All right, just a minute, please. Officer.
And I keep calling the document, the big flat document with the small font, as the mothership document. Good morning, ma'am. How are you this morning? Thank you.
the main document. So I see this.
Thank you very much.
But it's where in the main document? This is on page 10 of the matrix. And it was in reference to...
You have two matrices there. You need to identify which one you're talking about.
The main matrix,
The
page...
the mothership, okay.
The mother document,
All right,
page
good.
10.
All right, we're with you on page 10.
So we are just going back to one matter which we had indicated that we would have come back on, and then after we can resume from where we left off.
Yes.
So in regard to the definition of officer, there had been a recommendation that the definition in the Companies Act be used. The CPC...
You're saying officer or debtor?
Officer.
Okay, all right, I see it. That's section 2.2. We're recommending that there be a definition for officer. Right? I'm in the right place.
That's correct.
Thank you. Continue.
So, having reviewed the matter, we agree with the CPC that the definition in the Companies Act cannot be adopted and that the matter should remain as is. The reason for this is that the definition in the Companies Act relates to body corporate, where only, whereas in SIPA, officer is used both in regard to an incorporated and unincorporated association.
So you're going to keep what we have?
We will keep what is there.
Thank you.
Thank you.
Move on.
So the next recommendation would be in regard to section 49, and that is on page 33 of the mother matrix, page 33.
Okay.
And this is coming from Jamaica Bankers Association. So the recommendation that is there was in regard to removal of the need for the debtor to authorize the registration notice.
Before I go any further, please, the ministry team, I'm sure you do, but I just want to make sure we are reminded that the minutes of these meetings all have to be reviewed by you once they're written, because you have to make sure that what we agreed to do and not to do are accurately captured for the minutes, because the minutes is a record for the future. Okay? So when I haven't asked for any matters arising from the minutes yet, which I'll do before we close, but I just want to remind you that it's the job of doing the matrix and going over it is as important, listen carefully how I put it, as important as making sure the minutes are right. Okay? Thank you very much. Continue, Ms. Leon.
So the reason that the recommendation was made is that in section 49...
You're on page 34?
We are on page 33.
33, thank you.
So the recommendation was made because there appeared to be a tension in the section, in that one subsection indicated that the notice must be authorized by the debtor prior to registration, and then later it was indicated that the notice may later be authorized. So we disagree with removing the authorization because we believe that this is key, as the debtor is the party who will be prejudiced by registration of the notice. But what we do recommend is that the language be improved so that there does not appear to be any tension between the two subsections.
So you're going to amend the language some, but not change the meaning?
This is correct.
Right. No comments? We move on.
The other recommendation from the Jamaica Bankers Association is in regard to Section 57, which is on pages 37 to 38 of the main matrix. And this section allows the registrar to make amendments to regularize errors made by the registrar without making any provision, for the effect of the error. So it had been recommended that where there is loss or damage due to the registrar's error, that the person who is affected should be allowed to initiate or prosecute a claim for recovery of damages against the registrar, and that the cost of such action should be recovered from a compensation fund under the Act. The position is that this recommendation we disagreed with same because the general practice is that the law allows for indemnification from liability of public officers acting in the course of their employment in good faith, which is consistent with good public body management. However, where there is negligence on the part of the registrar, then a course of action is available, is already available.
So no need to change?
No need to change.
All right, no comments, so I ask you to move on.
The next recommendation from the Jamaica Bankers Association is in regard to Section 59, which is on page 38 of the main matrix. So the section requires the secured creditor to provide personal data, name and address of an immediate successor who had a security interest against a particular asset. And the suggestion was made that there be consideration as to whether the sharing of the information aligns with the Data Protection Act. There's no conflict between the section and the Data Protection Act. The request made and information requested would be considered as occurring in the normal course of business, which is provided for as an exception under the Data Protection Act. This means the security contract must provide for making and fulfillment of these requests. So in terms of how the data is treated once it is collected, the COJ will comply with the Data Protection Act. So no change is required.
Thank you. Next.
Some general comments were made by various stakeholders. Okay. All right. I'll go to the other specific comments before going to the general comments. So the next entity from which we have specific comments, many of which overlap with the previous recommendations considered. So we will just highlight where there's a difference or where there's something entirely new. And we will indicate our position regarding same. So it's the Jamaica Bar Association, and the first recommendation in regard to Section 2 is on pages 10 to 11 of the main matrix.
Okay.
So the recommendation was that the definition of intangibles expressly include for the sake of clarity, accounts, receivables, and relevant accounts. This recommendation, we disagreed with the same. The reason for this is that listing items in the definition can be restrictive. If the terms are not included, it is implied that the suggested terms are included as intangibles. Note also that the definition is similar to the definition of the term in the British Columbia Personal Property Security Act and in New Zealand's Personal Property Security Act, as well as other such legislation. So in other words, the definition in our law, it conforms with international best practice.
Okay.
Quick question.
Yes, Member Hilton.
So I've heard the response. The question I would ask is, in the research, when you say accord with international best practice, does that mean the case law as well as I mean, so it's one thing to have it in the Act as the courts interpreted those sections and given an indication that the requested change is implied or incorporated?
In the case of Canada and New Zealand, I think those are the countries you referred to.
All right.
Correct.
So in terms of research done, so yes, we would have looked at least 5 or more legislation, but in addition to that, we do have subscriptions to certain legal sites, and we did go on the sites to look if there are any conflicts, etc., and we did not see any arising in regard to that matter. Whereas there are other matters that we saw them arising there. And it's usually included there if there is any conflict which usually arises with the legislation as presented.
But you found no particular case
We didn't
law
find any
applying,
interest in this. That's correct.
Let me just, I understand the response, but sometimes it is out of an abundance of caution and for clarity. But let me pose the question another way. What harm would it do if it were to be included, just out of, again, for clarity and an abundance of caution, so that though the legislation is reviewed or drafted in a particular way, the recommendation, I understand, is saying to be explicit and to avoid any issue we may want to incorporate, to make clear that this is covered. What harm would that result in?
All right, so what we have seen is that the indication tends to be that listing certain things like that, it can result in the definition being restrictive. So, interpreted restrictively. So, whereas from the articles, etc., which may have been written by some experts in the area, some of which would have visited us locally, and they would have made their recommendations that in the same way that we have general definitions for, security interests, etc., which can cover a wide range of personal property, because the nature of intangibles, it changes. So you will realize that even in the past few years, there are several new types of intangibles which we did not contemplate before. So it appears that using something like, we don't want to say the use them generis rule may apply where you list some things and it is expected that is things of that nature that is included. So in this area, given the particular dynamism of intangibles which may be used as personal property security, the literature out there supports just leaving the definition as a general one.
So let me ask, you're saying that if you were to make the definition more narrow, and given that we're in a very dynamic and fast-changing business technological environment, you might in fact you would be excluding, in fact, other items or assets or considerations that should be in if you use, or would be in if you use a slightly broader, as you now have, rendition, rather than a more restrictive rendition, which will definitely be less inclusive.
Thank you, Chair. Yes, that is the position.
Okay, Member Hilton.
I understand the point being made. I'm not going to insist on it, accepting that sometimes it's a drafting point, but in the context of our economy, our country, if what is being requested is of particular importance, we may want to consider it. But I take the general point, and I hope and believe that reflection, that it will reflection and point in a more profound, so that it's not just simply what Australia and we do, but not the economy is different and functions different. That we take, whatever taking that into account, a particular reason to want to explicitly state that. Again, without limiting, and there are ways in which to do that, and the drafters know that. But, so be it. If the work has been done and there's general satisfaction, what is being asked for is could be implied interpreted to be part of the motion. Right.
I will, Member Hilton, I'll just ask the team to just double check with the CPC as the drafting is done to make sure that the concerns between being too narrow and somewhat restrictive is properly balanced against the consideration of being more inclusive with a broader rendition. So I'll ask the team to take your point into consideration as the final draft is being done.
That will suffice.
Thank you very much, Member. Continue, Ms. Leo.
The next recommendation in regard to Section 2 from the Jamaica Bar Association, this was already proposed by MIC and also JCCUL, and the only difference in regard to Jambar's presentation is in addition to the addition of the words and any transaction to which this act is applicable by virtue of Section 3. So we're still looking at Section 2, Jambar, 10 to 11. So Section 2, remember, for Jambar was pages 10 to 11. So they also had made some recommendations in regard to the definition of security interest, which was substantially the same.
Which page are we on?
It would be page 11.
Thank you.
So the additional words that they proposed and any transaction to which this act is applicable by virtue of Section 3, etc., we agreed with this position, and we agreed with this position because Section 3 lists the various type of security interests. So the proposal made here is similar to several other territories, how the drafting is done, where the general definition of security interest is then cross-referenced against the section which specifically lists types of personal property.
Okay. Any comments? No comments. Please continue.
The other change in the definition section made by Jambar in regard to serial number and serial numbered property, this was accepted and this was already proposed by MIIC.
Okay. That's one easy. Move on.
In regard to the next section in which a change was recommended by Jambar is section 5, and that's on page 14 of the general matrix. And this too was already proposed by MIIC and already accepted.
Thank you. Move on.
The next change is in regard to section 8 of the Act, and this is on page 15 of the general matrix.
Okay.
And this was already discussed except for, and there was agreement from the part of MIIC and COJ, although the OPC is not necessarily in agreement with the rephrasing of the section. But it's a drafting issue, and they had indicated that they would revisit the drafting. The only difference is that Jambar also included the phrase unless otherwise provided by this act, and we agree with the inclusion of these words.
So you agree with Jambar?
We agree with Jambar.
And OPC will refine.
And OPC will refine. Thank you.
Thank you, my dear. Continue.
In regard to subsection 6, this was already accepted of that same section. In regard to section 18,
page,
and this is on page 19 of the general matrix.
Okay.
This was already discussed, and we had accepted and agreed with the OPC that since subsection 2 already indicated that the minister has power to change that figure, that we really didn't need to make any change.
Continue. Thank you.
The next change was proposed change by Jambar was in regard to section 19, and this is on page 19 to 20 of the general matrix, and this was already proposed and agreed by MIIC.
All right, thank you. Next.
The next change was in regard to section 32, and this is on page 25 to 26 of the general matrix. Subsection 1, it was already discussed and already accepted. Subsection 2, for the highlighted portion, we accept the suggestion by Jambar to include the words howsoever same may be appointed. So what Jambar was seeking to include is that for the trustee or the liquidator, you should include the words that they have the powers granted by that section, howsoever they may be appointed, since there are various methods by which they may be appointed. And we accepted and agreed with same.
Sounds good. Move on.
All right. The next provision was in regard to subsection 3 of that same section 32. What was not discussed, but which we did agree and accept, is the inclusion of a provision indicating the trustee in bankruptcy of the debtor's estate shall be entitled.
Which page are you on?
Oh, sorry. That is still, those submissions would be still on page 22 to 23. It's likely on page 23.
All right, thank you. Continue.
So this is giving the trustee the power to file a registration notice with respect to the bankrupt's estate, specifying the details as set out in the Act. And we agree with this in the sense that the trustee would want to ensure that nobody deals with these assets when they are not supposed to be dealt with. So putting the registration notice on the NCIP registry would assist with that.
Okay, good. Continue.
And then B of that, section 32, subsection 3B, the inclusion of the words, if the trustee in bankruptcy files a registration notice. And we agree with that. And C seeks to also include these words, if the trustee in bankruptcy does not file. So we agree with these changes being made.
Thank you very much. Move on.
The next proposed amendment was in regard to section 35, and this is on pages 25 to 26 of the main matrix.
Yep.
And it's in regard to, for section 35(1)A, we already discussed and included this, and this was adding certain words to the subsection there. In regard to section 35(1)B, this was substantially accepted, but the Jamaica Bar Association, so in this section, at lines subsection B, 1, 2, 3, 4, 5, 6, they wanted to add the words, so after accounts receivables, financial instruments, they then put or other intangibles. And we agreed with this recommendation.
Good. More agreement. Move on.
Yes. And the same would have pertained in regard to subsection 2. And then under subsection 4, they recommended the inclusion of the words or other person obligated to make payments. And we agreed with this because, as we are well aware, in terms of commercial practice, it may not be the debtor who is obliged to make payment. It may be some other party.
Right.
The next proposed change was in regard to section 37, and this is on page 29 of the main matrix.
All right, just a second. Dr. Longmore has joined us. Welcome, and we continue, Ms. Leon.
This was already accepted. The recommendation.
That should accurately have been Senator Dr. Sophia Longmore.
Thank you, Chair. Thank you. Good morning, all.
And I've just been told that Professor Morris has just joined us, and welcome, Prof.
Thank you very much, Mr. Chair.
Okay.
Continue, Ms. Leon.
So the change, as supported, is that Jambar wanted us to include treating with intellectual property that is owned and that is not just the subject matter of a license.
And tell me the page again, if you will.
And this is on page 29.
Thank you. And that's for the new joiners, that's page 29.
Of the main matrix.
Of what I call the mother document.
The mother document.
The one that is written in fine print.
That's correct.
To be differentiated from the other matrix.
Yes.
Thank you.
The next change proposed by Jambar is in regard to Section 48, and this was substantially discussed and accepted, except that JAMBAR, in providing further clarity, recommended inclusion of the words subject to Section 58, provision of information to the registrar. And we agree with that because it's merely to assist in terms of interpretation. The next proposed change was in regard to Section 49, registration notice. This we disagreed with. It was, and it is in regard.
That's on page 33.
Page 33 of the mother matrix. And we disagreed with the recommendation to indicate, if applicable, the maximum amount of principal indebtedness. And on the last occasion, we would have indicated it is best to include a maximum amount because of one, all the reason that the data is required, and so we did not accept this recommendation.
So you want to put a cap on?
We want to have a monetary value stated.
Right. Which will mean you'll have a cap.
A cap, thank you.
Cap. Okay.
Yes.
Comments, members? No comments, we move on.
No, just a general question.
Yeah, yes,
And
yes,
rationale-
council member,
the
as in
rationale
council.
The rationale for the cap is what again? Please remind me, what is the rationale for the cap?
All right, so the cap, why we recommended keeping a cap there. So you will recall when we started these meetings, and there were several questions regarding the use of the registry, the dollar amount that was now represented in terms of how many, the value of the loans granted. We have several national and international organizations who want to know what is the value of loans.
I agree, I agree.
Yes.
All right, good. Thank you, Member Hilton. And we move on, Ms. Leon.
So the next recommendation in regard to Section 50, and this is on page 34 of the mother matrix. And this recommendation was accepted because, again, it provides clarity by linking two sections that relate to each other. So JAMBAR suggested that subsection 1, including the words subject to the provisions of section 52, which deals with effect of defects or irregularity.
Thank you. No comments, move on.
In regard to 51, the changes proposed by JAMBAR in the section, I think it had amended notices, but it should be an amendment notice, and this was discussed and accepted previously.
As on page 35.
As on page 35. In regard to the next proposed change was in regard to section 52, and this is on pages 35 to 36 of the mother matrix. And we disagreed with what was being proposed by JAMBAR for the reason that it would provide less clarity and more ambiguity. They wanted to indicate that the validity of the registration notice is not affected under subsection 1, whereas the current law clearly indicates that it's void. So when you say not affected, there may be some ambiguity as to what does not affected means, whereas the current law clearly already states that it's void if it does not have these elements.
Sounds pretty clear to me. But what do I know? My lawyer friends, any comments? All right, no comments, we move on.
So the next change in regard to 52, which was, that part was accepted, is in regard to including accurate number of the serial numbered property. So we had introduced serial numbered property. We put it in place of serial number in relation to motor vehicles. So their change here was simply to indicate.
You broadened the category. You broadened the items that would be involved.
Thank you, Chair. This is so. All right. The next proposed change was in regard to section 56, and this is at page 37 of the matrix. And this is a typographical error which was already accepted. But it should be in regard to, Sharice, was it, the document had, I think, 5A, but it was supposed to be B? We changed it? Okay, so even though Jambar had 5B, the correct reference is 5A, so reuse is there, but it should really be refuse.
Okay, so it's a typo error,
A typographical
and that is
error.
being corrected.
And it is being corrected.
Thank you very much. Next.
The next change was in regard to section 58 on page 38 of the matrix. And this was already discussed and agreed, where instead of referring to serial number, to motor vehicle, we substituted serial numbered property.
Right, again, you broadened the definition there.
Definition was broadened.
Thank you. Move on.
And the next proposed change was in regard to section 62, and this is on pages 39 to 42 of the main matrix. This was already discussed.
This was a big one. We discussed
Yes,
this.
the conflict of law, and we indicated that we would use the uncitral provisions.
Right. I remember that.
Right.
Thank you. Next.
Right, so the next proposed change,
Does this mean we're finished with the big sheet, the big mother sheet?
not as yet, Chair.
Not yet. Okay, continue.
The next proposed change,
Oh, we have a couple of pages left, yeah.
yes, the next proposed change was in regard to section 67, which is on page 42 of the mother matrix. And the proposal here is that the section should be amended so that stamp duty is not payable. We disagreed with this because the provision is consistent with the policy at the time when SIPA was brought into effect. Consultations were done, and it was clearly indicated that stamp duty is not affected by the Act, and the Ministry of Finance had indicated that they are not prepared, to exclude the stamp duty being applicable for various financial considerations.
And so what is the final position?
So the final position is that we disagree with the proposal to remove the application of stamp duty to the
So the stamp
transactions.
duty on this instance stays.
The stamp duty remains.
All right, thank you very much.
May I ask?
Yes, Member Hilton.
So I hear the reasoning, and it is the case that when SIPA was being brought into first being discussed, the country was in a different economic condition. Has there been any subsequent, for this review process, has there been any subsequent discussion with Finance, the Ministry of Finance, for their consideration?
Coming back to you in a moment, Member Hilton. Yes, Ms. Leon.
So whereas there may not be a written document, but because discussions were in fact held in which it was indicated that because no new taxes are being introduced, the status quo needs to remain so that the revenues collected would not fall significantly below what is projected, and that if the stamp duty was removed from these transactions, it would have significant impact in the environment of no new taxes.
When was this discussion held is one of the part of the questions of Member Hilton.
So there would have been different occasions in which there were persons who would have gone to the TAJ to say, well, do they need to pay taxes on these transactions, etc. And so this would have been about 1 month ago.
And so this would include that this would affect that broadened definition, that broadened the serial number issue from cars to whatever else has a serial number, whether it's your blender or your washing machine or whatever else. Is that right? This stamp duty is in relationship to that broadened definition that you mentioned twice back. So that's a question from me. I'm not sure.
So it is not so. The stamp duty, it existed prior to SIPA, and it continues to exist during SIPA in regard to transactions in which where you are creating a security interest in certain items, you need to submit the documentation.
On any asset, it's not just serial number type.
Correct.
So it's a broad category that would really do affect the revenues.
That's correct.
And given that, I imagine finance accurately saying that we have cut income tax twice, cut GCT from 16.5 to 15, this is probably not the time. And we've spent over $100 billion in terms of helping us through the pandemic without borrowing money or raising taxes. This is not the time to remove this. Member Hilton, that's the argument.
Well, just a rejoinder to say, similarly, the Ministry of Finance, even within this broad context of no new taxes, has been making discrete and particular exceptions of what they call nuisance taxes and all of that. So I just want to make sure that an updated conversation has been had in light of changes that have come about from the time that SIPA was being introduced, because there is and should be an incentive for persons to want to do more in this realm of security interest in personal property, and you want them to register and to securitize those interests. So there could be an incentive, but if I'm being told that the consultation was had, and that is a decision.
And very recently, in fact. And one of the things that might be somewhat modifying this issue is that since the SIPA legislation was considered, Member Hilton, in the 2013, wherever it was, the stamp duty regime has been reduced significantly by this administration, so it's not nearly as high as the time when it was being considered. So I think the argument about where we are and having taken place just a month ago with finance, I'm going to go with finance for the time being, and if there's really a need to amend later on, we can always look at it. But I think we're probably in a good place. A better place would be no tax, but we're not at that point at this stage. Thank you. Ms. Leon, can you continue?
In regard to Jamaica Bar Association, they had made some general comments which do not necessarily relate to any specific sections, but they're important that we need to mention them. So the first one was in regard to floating charges. So they recommended that there should be a provision which expressly states that they wanted a definition of floating charges to be included in the law and to create a carve-out in regard to same. It's not in the matrix because they had maybe subsequently sent a few other things, but because it is something which is important, we wanted to mention it nevertheless. We disagreed with this provision because the regime that we are coming from, which is registration of charges under the Companies Act, there is a legal framework that comes with that. The security interest under SIPA comes with another legal framework. In regard to a floating charge, why is this being proposed? One, the floating charge provides that you can take a loan over, for example, general assets, and nothing fixes at a particular point in time. So you can just keep turning over your stock in trade, and it does not impact
the business, the operation
the business.
of the business.
That's one. It also includes any future acquired property. So why did we refuse this recommendation? One, under SIPA, it provides for when attachment takes place, and it sets out the condition for when this happens. But importantly, it indicates that the security contract can provide for the collateral to be passed on without a charge being on it or without there being any debt affixed to it. So all you really need to do is to provide for that in your security contract. It also indicates in SIPA that your security contract can include the fact that the security interest applies to after acquired property. So SIPA already includes provisions for the benefits that derive from a floating charge. And trying to mix the two principles, one, it's not necessary because provision is already in the law. Two, you are going to create some conflict and confusion when you are looking at case law from other jurisdictions, because that's what we have to look to at this point, given that the regime is not mature.
Okay. Next.
The next recommendation was in regard to the establishment of a system, basically the need to remove multiple registrations. So this was in regard to, for example, motor vehicle liens. So the fact that for the security interest on the motor vehicle, this is recorded on SIPA, and then at the TAJ, the lien would also be recorded against the title to the motor vehicles. It does exist in other jurisdictions, but the framework in Jamaica is not the same as those other jurisdictions. So for example, I think like in Panama, where they have one department which deals with everything, and so you can have that. The framework just does not exist in Jamaica, and this would involve massive amendment to a number of different legislation, different policy, etc. So we could not accommodate that using this legislation only.
All right. Thank you. Move on.
All right, I think in regard to their general recommendations, the other things that they would have said, it will arise when we're dealing with recommendations from other, general recommendations from the other stakeholders. So,
All right, where do we go now?
Miss, just a minute, please.
While Ms. Leon is looking, is searching, may I just inquire?
Please go ahead, member.
Yeah, the recommendation just addressed just now concerning the dual or multiple registration. May I ask if, following on the previous discussion about stamp duties, are there charges and duties and charges attaching to the registration in either at the company's office or the
Ministry?
or the title's office?
Oh. Can you answer that, please?
So in regard to, so the specific recommendation was in regards to TAJ, which was in regard to motor vehicles specifically. And TAJ does not have a charge. Under SIPA, there is a charge for a registration notice. In regard to NLA, they would have been dealing with the fixed property in regard to mortgages. There is, however, a security contract that can be over personal property, but it includes a fixed interest in land, and they don't have an issue with that, and they never made a recommendation in regard to that. However, so there's no change proposed in regard to that, because persons want the fixed property, the charge in the land, to be registered with NLA, and in regard to the rest of the assets, other personal property, even though that document has a fixed charge in regard to land, it would be registrable anyway. And so they do register that document on the SIP registry.
To be clear then, my question is, at the SIP registry, at the ministry, there's a charge attaching to that, right? An administrative charge.
There is a registration notice charge, yes.
Yeah, and at the TAJ, there is another charge attached.
No, TAJ does not. They don't have a charge.
No stamp duty or anything like that.
No, but that's a different thing. Well, in regard to, so what this particular point that they were making is in regard to registration itself. So the stamp duty, which would be applicable on a security contract, that would apply. But so that was a separate point. But this recommendation that they were making really is that they don't want to, in regard to motor vehicles, have to approach both the SIP registry and the TAJ.
Well, one of the objectives of this exercise is really how we can get SIPA to function better, and therefore to look very closely at those things that may be inhibiting the use of the act, and I believe we should look at anything that can assist that effort, and then the balancing that has to take place necessarily, that we look favorably as to how we can simplify the operationalization of that. And I'm asking, in viewing that light, if there's any opportunity here for us to give further consideration or give due consideration to this recommendation.
So any recommendations put forward, we have in fact where it involves third parties or other ministries or departments, they have been put forward to SAME, but also functionally now the TAJ and the COJ, as far as motor vehicles are concerned, we do work together in regard to SAME, and we do have an agreement in regard to what should be done, how it should be treated, given that both agencies have to be involved in this matter. So yes, we do take on board any suggestions made, and we do present them to the other parties who are impacted.
Any other comments? We move on.
If there are no other comments on that, the DBJ, in their general recommendations,
Yes.
Even though they had put them forth as general recommendations, they had recommended amendments to specific sections. So the first amendment, which was made, was in regard to section 28, and that is on page 21 of the Mother Matrix. Page 21.
Okay.
And the DBJ noted that in regard to section 28, which deals with liens, and section 30, which deals with holders of negotiable document of title, they asked that a review being done, in regard to the same, given the ease at which a secured creditor's interest may be subordinated. We note the comments. There was no specific recommendation made. These circumstances would be applicable in limited cases. We note that section 30 of SIPA is similar to section 72 of the Australian Personal Property Security Act, section 96 of the New Zealand Personal Property Security Act, and we note as well that section 28 is similar to section 93 of the New Zealand Act and section 32 of the British Columbia Personal Property Act. We examined others as well and noted that the sections, the provisions were the same. In looking at the legal research engines, we did not see any issues which arose. We did not find any articles we weren't looking for cases specifically, but the sites would generally list cases if there are cases. So there appeared to be no legal concerns regarding same, and the provisions appeared to be in line with the international standards.
Okay.
The other recommendation.
Just a second. Did you ascertain, are you clear as to why the DBJ, what the particular concerns of BBJ is as a creditor, as a potential creditor in this particular provision?
Yes, they did indicate in the rationale that they had concerns as to the ease at which the secured creditor's interest may be subordinated.
But you agree with that assessment about the risks attaching to that, with the ease with which that could be subordinated, and how would this provision, their proposal, address that particular concern?
So we did consider their concerns, and one, we looked at the general schema of the Act to see where certain exceptions or exemptions were made. Two, we looked at internationally, how are these areas treated, and without fail, in all cases, they have been treated the same internationally where these exceptions have been set out. And we did not find any written papers which indicate that there should be any need for change. But if we were to make a change, we would go against the international best practice. We would then find ourselves as well without legal jurisprudence that we can rely on. And the persons who had previously consulted with us and who continue to consult with us, there has been no recommendation made from those persons.
No, but was the question, was the issue raised with those persons? See, I'm concerned. I'm concerned that I understand the need to look at international best practice. I understand the need to try to stay within a certain framework, but equally, I'm trying to deal with a situation where we are not getting the same kind of, they operate differently. We have different economies. They operate differently. The same piece of legislation operate differently in the different jurisdictions for a variety of reasons. I'm just saying that if what I'd want to know from DBJ is, is it that they've had some experience or experienced some problem in the use of the Act, or they're simply trying to preempt a problem that they foresee?
So from their presentation, from discussions with them, it appeared to be a hypothetical situation where they are indicating, but if in certain instances it appears, based on the fact that you have carve-outs for different type of personal property, that they could have a challenge with a secured creditor's interest being subordinated to persons who hold another type of personal property. But for these type of personal properties, based on the nature of them, so both in regard to creation, when the security interest attaches, perfection, so the whole regime treats with them consistently different because of the nature of them. So for us in one area to now go and change how the law would apply to them, it would be problematic. So throughout the legislation, the vein is, for this type of personal property, this is the carve-out in regard to attachment. This is the carve-out in regard to perfection. This is the carve-out in regard to enforcement. And it is treated the same internationally. So what I want you to know, we did not just slavishly look and say, because it's the same internationally, we cannot make a change. We considered from beginning to end the treatment of these assets. And we did do the research to see if exceptions were made elsewhere and how it was treated, and they were not. But it's particular because of the nature of these assets why the exceptions have been made. And DBJ did not indicate that they have any specific problems. It's just, what if this could?
Yeah, okay. All right. Okay.
All right, thank you. Go ahead.
All right, the next section which they commented on is section 48 in regard to the fact that, oh, sorry, this is on page 32 of the mother matrix.
And the issue is?
They proposed that, so the law currently says that registering a notice does not automatically equate to constructive notice or knowledge of its existence or contents. So they wanted registration of a notice to amount to actual notice or actual knowledge of the existence of the notice or its contents. We did not agree with this because of how the regime itself operates. So under SIPA, it is indicated that you may in fact register a notice even before you have, say, disbursed any funds or done anything like that. You may intend to enter in a certain transaction. So the whole idea is that SIPA is a notice registry. It gives notice that a security interest may exist, and therefore a secured creditor needs to go ahead and conduct due diligence. So because a notice is on SIPA does not mean that the transaction was followed through to perfection. However, the secured creditor does have an obligation if the transaction did not proceed to completion, or if the transaction took place and the obligation has been satisfied, or if there is some other agreement, there is the obligation to file a termination notice. So in light of this, we did not agree with the recommendation, and we further checked other legislation, and the provision that we have is consistent with those legislation. But the earlier rationale given is why we did not support the recommendation.
And I tend to agree with you, given the kind of clients that we're dealing with.
Yes.
They don't have big law firms and big accounting divisions. Everybody must be notified. They have an obligation to do that, so I agree with with your
That
position.
is so. Thank you. All right, so it's just the general complaint? All right, just a minute, please. All right, so I'll just move to the general comments from stakeholders. So we had some general comments from different stakeholders. And in regard to these general comments we can start with Development Bank of Jamaica. We discussed those.
We're going to look to close this session in about 15 minutes.
We will be finished, Minister.
Okay, thank you.
So in regard to the general comments, recommendation 1 from Development Bank of Jamaica, this was legislative in nature. It's on page 1 of the general matrix. And we already discussed and included same. And this was in regard to disposition of the secured property. In regard to recommendation 2 from DBJ, which was under their general comments, this was also seen to be legislative, and we dealt with this, and this is on page 2 of the general matrix. In regard to recommendations by DBJ set out on page 3 of the general matrix, we all right, so in regard to the DBJ on page 3 of the general recommendations, these were found to be in regard to the wider SIPA framework. So it's not matters that we would change the sections in the legislation, but matters for further action, further working together. And these matters include the fact that there are no documented titles which are available for certain personal property, the fact that you can dispose of secured property without the consent of the secured creditors, the fact that a secured creditor has many enforcement hurdles that they have to go through. So it was comments like those which some of them, it applies in any kind of lending situation where persons may breach the contract and do what they're not supposed to do under the contract. In regard to LASCO, microfinancing, their general...
Good. Yeah, somebody had a comment?
Yes, Jeffrey Foreman, Attorney General's Chambers.
Mm-hmm. Yeah.
Right, I'm a little lost as to where we are in respect of the general recommendations, and in particular what decisions, if any, the committee has made or is being invited to make, or are we at the moment simply just highlighting what the recommendations are without discussion on them?
All right, so as indicated,
Before you answer, I did ask at every submission, any comments, and where there were comments, they were taken. So no comments, we accept and move on. That's where we are, but Ms. Leon, you might want to clarify more.
What we just did is, where general comments were submitted by stakeholders, and these general comments gave rise to legislative change, we would have included those in specific recommendations. There were other general comments made, which, for example, dealt with the transient nature of personal property, the fact that you may not have any title to it, the fact that it may be hard to define what the personal property is in regard to, for example, crops, the fact that there's no secondary market, the fact that there's a lack of valuators. So those type of provisions, so we circulated a document which I saw Ms. Cohen would have sent out last night, and in that document it was indicated in regard to the general recommendations, the pages on the main matrix, whether or not they required legislative action or whether or not it is concerns to do with the general SIPA framework, which would then not require legislative amendment, but would suggest the need for coalesced future cooperation among various stakeholders. And we have, during these meetings, met with the several stakeholders, and we have made several suggestions as to some linkages and continued discussions which could be held.
Okay, thank you for that. Well, let me ask a specific question then. So I see that one of the recommendations that DBJ made, for example, dealt with criminalizing certain dispositions of property. What's the ministry's, what is the ministry inviting the committee to do in relation to that one, for example?
So we did not invite the committee to do anything. The Act has various provisions in regard to enforcement offenses when you breach the security contract. So there would already be provisions under the security contract, and the Act itself does not prohibit any other remedy which would exist outside of the Act.
Okay, so the recommendation is not being accepted to criminalize the disposition?
No.
Okay, thank you, because I saw something else on the matrix. I wasn't sure.
Okay.
But thank you, that's helpful.
All right, thank you for those questions.
Thank you very much. Moving on.
All right, in regard to LASCO financials, the general comment that they made, difficulty in proving ownership, difficulty in determining value, no independent valuators, lack of proper title, easily transferable and difficult to track, cost associated with independent verification, cost associated with storage, etc. So again, those type of comments would not be something that would necessitate a legislative change, but it would lie in further action and discussion in terms of cooperation outside of the legislation. In regard to the Faculty of Social Sciences, so the Faculty of Social Sciences, they made a valuable contribution as well. Those comments, however, did not recommend or would not relate to any specific changes in regard to the law. So, for example, they had concerns regarding ease of use of the registry. We investigated same, however, the customer satisfaction survey from the persons using the registry, the regular users, we had over 98% satisfaction. Generally, when we go to forums, meeting with the lenders as well, they make recommendations to us, and as a part of our annual maintenance contract, persons, we are allowed to do 3 upgrades annually. So we usually treat quite readily with any recommendations made. They also indicated that...
Mr. Chair?
Yes, Member Morris.
Save and except as it relates to the use of the registry, we have to make sure that the information is available in an accessible format for persons with different types of disability. Because since we have made amendments to the law that is going to accommodate a wider cross-section of individuals, we have to make sure that the information at the registry is in an accessible format.
This is noted, and we do realize that all legislation and infrastructure needs to be inclusive. So this is something going forward as we consider the registry that we will see what changes we can make.
All right.
All right, so in regard to the general comments made, they largely mirrored the other ones that I would have just listed. The fact that the market has not changed much, it's traditional collateral which is being accepted, that there's no secondary market. So those type of comments. And rather as well, their general comments, the first comment, well, all of these were in regard to legislative changes that they made. These are on pages 1 of the general matrix. However, the recommendations that they made, it was already included in the law. So they were indicating certain types of personal property which the law should cover. These are already included in section 3. So it underscores the point again that we have to continue to ramp up the sensitization so that persons are aware of what they can use the act for. They also made a suggestion in regard to water rights and including same under this law. We did our research. What we found is that several things. In most jurisdictions, water rights, they are not included under the personal property legislation. In UCC in the United States, in some states, they are included. In other states, they are not included. We also did the research and we found there was a lot of legal challenges when you include the water rights. But the main consideration was this. At this time, we do not have any sort of infrastructure which would make it meaningful to include water rights. But we've seen that it is highly contentious, highly legislated, etc., and a lot of uncertainty. In Jamaica as well, so water runs with the land. There are several challenges. But the main point is anything we introduce, we want it to be able to use practically from several angles. This is not something that could be actioned at this point in time. in regard to the next general comments, these were made by the Bank of, so in regard to RADA, they also, so the other comment was in regard to recommending use of personal property, which is already included under SIPA. The next general comments came from the Bank of Jamaica, and they were indicating basically that the statements that they made is that we should ensure that we conform with the Data Protection Act, which we would have already included what we have done there. So in a specific recommendation, we lifted out information which the registrar would be obliged to provide to the public, etc. They also dealt with their Banking Services Act, and they indicated that they have moved from a prescriptive form as to what assets can be accepted, and that they have now utilized a principle-based approach. So at this point in time, it's a follow-up meeting that has been requested, and the chair has already requested this meeting. So a date is to be agreed. And so it's not legislative, it's meeting to see how we can get a more favorable outcome based on the principle-based approach pursued by the Bank of Jamaica. And then the final set of general comments or recommendations. So the Jamaica Association for Microfinancing, all of those things basically which we would have referred to before, they have already been treated with, where they are dealing with things like the lack of the secondary market, the lack of knowledge about how to utilize and leverage this type of collateral. So those general comments, so they did not make any specific recommendations for changes to the law itself, but for improving the ecosystem. And then from the Bankers Association, they basically, in their presentation, entreated that their regulator improve the principle-based system which is in place, because when audits are done, they might find themselves running afoul of those principles. And so the meeting which is to take place, these concerns that they have would be discussed. So those were the specific and general recommendations which arose in regard to the Security Interest in Personal Property Act.
Chairman, may I just add two quick comments? Chairman?
Yes, Member Hilton, go ahead.
Yeah. Firstly, like the Bankers Association and Ms. Leon indicated, this discussion with and we all accept the discussion with the Bank of Jamaica is urgent and important, and that I hope that that meeting can be had soonest, because it is that collaboration, coordination, I believe, is central to a functioning SIPA. One, I wonder, Ms. Leon, some of the comments made and the constraints on the use of SIPA have to do with the market and the operation of market for disposition for example. And I'm just wondering if we should, and the market have to do with, in part, the size of the market and what is practical. Can we not, should we give some consideration, or asking that consideration be given to look at the regional market? And this is what I mean is, how many CARICOM countries are using the SIPA Act? I think that I would be interested to know that. And if there are, other than Jamaica, which I suspect, whether there isn't discussion about regionalizing some of the market so that you have an acceptable, well, you have a market size that would incentivize private actors, creating some of the opportunities for secondary market and that sort of things that can make the SIPA Act more functional, and the ecosystem improved. I just want to recommend us looking at that. We may find that there is some answers there. Thank you, Chair.
Okay, thank you, Member Hilton. Miss Leon?
So in regard to, I know that you specifically mentioned the market, Member Hilton.
And enforcement, other issues, other constraints.
Right. So in regard to the evaluation issue, we had previously reported that JIPO actively has some efforts going to assist with that in regard to intellectual property. And in regard to the matter of collaborating in the Caribbean, I know that we have had consultants, for example, from out of Trinidad, and we were considering, for example, when it comes to like equipment, certain type of equipment, being able to leverage these so that there is a market throughout the Caribbean. I do know that there is an effort now by the IDB where they're dealing with different type of innovation, and which would include things like this. So there's a group that is currently being formed, but we will continue in terms of doing the research and getting technical assistance to improve the ecosystem.
Okay. Okay, I want to encourage that.
Continue.
That concludes the submissions that we wanted to make to this committee.
All right, thank you very much. There was an item from the minutes that you showed me. We move on. We can leave.
Mr. Chair.
Yes, Professor.
Just one small point that I want to make.
Sure.
And it's a point of commendation to Mrs. Leon, to express my personal appreciation as a member of the committee who has a visual disability for the able way she went through the matrix and allowed me to follow the discussion with just ease. And I never had to worry about anything, any confusion. It was just seamless for me, and I really appreciate it.
Indeed, Prof. Morris, we appreciate those comments, and you are in fact following a line of those comments from our other members at other time. And to expand that, clearly the company's office as a lead agency on this from the Ministry of Industry, Investment and Commerce would be right up front, but right behind her are Mrs. Sutherland Reed, who's our senior legal official in the ministry, and her team.
Yes.
But I know as well that Heather May, to her left, and Sharice and Miss Allen at other times have been great assistance.
Yes.
We have to recognize the people from the OPC as well, the drafters who have constantly been here, and other assistants. But really, yes, the front person has been very consistent in outlining these changes, and I want to accept on our behalf as a committee your comments and the others before you, and to say I add mine to the compliments you've extended to Ms. Leon and her team. Thank you so much.
Thank you, Chairman. Thank you, Member Morris. So I just also wanted to underscore, it's a team effort. As you indicated, we work very closely together with the ministry in terms of evaluating these comments and providing responses. Thank you.
Members, if there are no other comments, I'm going to then ask Professor Morris if he would move for the termination of this meeting until the next time the clerk tells us that we will meet to continue and try and finalize this piece of legislation.
Well, if there are no other comments, Mr. Chair, I so move that this meeting be adjourned until such time.
And Member Hilton, will you second the motion for me?
Seconded.
Thank you. That's done, moved and seconded. And thank you all, members who have been present today, those clearly have been in line, and for all the staff here at at the House of Parliament, Ms. Coyne to my left, and others who have helped us, and of course the team from the company's office and the ministry itself. Till the next time, thank you all very much.